less so now. And I actually take a far more optimistic view than Ian. I'll explain why. Now, let's focus on those societal values of law being interpreted in the anthropocentric approach perspective.
I can't urge you to do it briefly.
Right. In September 2008, the following appeared in a new constitution. Nature, where life is reproduced and exists, has the right to exist, persist, maintain and regenerate its vital cycles, structure, functions and its process in evolution. Every person, people, community or nationality will be able to demand the recognitions of rights of nature before the public organisms. The application and interpretation of these rights will follow the related principles established in the Constitution. That's Article 1 in the chapter called Rights for Nature in the new Ecuadorian Constitution. Now that Constitution is the first globally which actually recognises what Christopher Stone called for in 1972 in his seminal essay of basically rights for nature, rights for trees, which he was published in the Californian Law Journal in 72. It took 30 whatever number of years before we saw a constitution changed. We do have about 15 constitutions in other countries which refer to the environment, and some of them are in the context of we are entitled to a healthy environment for our well-being from a human perspective. But that Ecuadorian constitution is the first globally. Now, it was being used to very good effect by the President of Ecuador at the Cancun discussions last December in Mexico. And he got up, incredibly charismatic person, who got a standing ovation twice in the addresses that I saw from the assembled number of delegates, that he was able to get across a concept of us being a mere part of the environment. And that is what we should do when we look at how we frame our laws. And to that extent, I agree. But I think we actually have come a very long way. And I'm a strong believer that you can approach reform in a gradual evolutionary approach with a softly change in the reforms to law, because that then can infiltrate through decision making as a whole. Now take for instance the Rio principles of sustainability. You will know many of them, and the intergenerational equity and the precautionary principle are but two of the 10. Now, we have seen in Australia over the course of the last 10 years a progressive inclusion of those principles into environmental law. You look at sections 1A to 1L of the Environment Protection Act in Victoria as an example, and you will see that those principles are there. And section 1 says that the EPA, in performing its official functions, must take into account those principles. Now, you might ask, are they taken into account sufficiently to influence the decisions? Well, the very fact that they're there and are referred to and do influence the decisions to a certain extent, not always with the result that one would like, but they certainly do influence the decisions in a real sense, gives me hope. I'll give another good example. Philip Sutton was a very early environmental campaigner in the late 70s, 1980s. And he came up with the concept of protecting biodiversity by focusing on our rare and endangered flora and fauna, and basically a charter of rights for nature in this state. And it was called the Flora and Fauna Guarantee Act. That's what it came. It was the first seminal piece of legislation to look at the protection of endangered species in this state in decision making when you're developing things. Now, it has been patchily applied. I do agree with that. And we've got huge issues of grasslands in the western part of the city as an example, where it's really tough issues of how you apply that act. But what that led to was an evolutionary progression of environmental laws being enacted across this country. which have led to the biodiversity provisions we have in the Environment Protection and Biodiversity Conservation Act. And in every state and territory, we have legislation which looks at those issues. And it is so that on an everyday basis, I do see decisions that take into account and do reject things and do modify. Yes, it is true that with application under the EBC Act, there have been a handful of rejections. But rejections is not the only influence on decision-making in environment. It's also the modifications that comes from conditions in permits, from actually saying, well, if you're going to do this, if you want this development entitlement, then you're going to have to do it within this sort of constraint. So I actually think, as an environmental lawyer, that we have made enormous progress over the years. Climate change, well, I actually think that the rolling out of climate change laws that we are seeing at the moment is having a huge change. There hasn't been a decision regarding coastal development in the last 18 months in this country that has not taken into account the impacts of climate change. And in this state, the tribunal inevitably rejects coastal development if they think that the precautionary principle is indicating they ought to reject it. Water management, I won a seminal case 18 months ago in this state regarding groundwater management. And I was able to latch on to those principles that appeared in the EPA Act and latch on to the exact same sustainability principles as they appear in the State Environment Protection Policy for groundwaters and for waters of Victoria, where they are recited, and say, look, if you're going to honestly consider this decision in the context of those decisions, you must apply the precautionary principle. And yes, we have 4 experts in this case who are at loggerheads as to what the impact of climate change is going to be on the provision of groundwater into the future. But you must look to the future, the intergenerational equity aspect, and I read it out, and I read the principles from cases all around the country and the world. And then I went into the precautionary principle and I said, I don't think you've got any choice. I have to say I walked out of that tribunal after the days of arguing, feeling somewhat pessimistic. We had an engineer, in fact we had 2 engineers, and we had an environmental lawyer that I have a great deal of respect for. But I thought at the end of the day, because we had a huge team against us, the most senior QC in this field in Victoria against me, and they argued the case fabulously. But as it happened, we won 100% of the issues. And that gives me hope, Ian, that I actually think there is an enormous role for environmental lawyers. I think there is an enormous opportunity to influence. And yes, you need that change at the end, societal change, the radical change, but that sets the context for the evolutionary, softly approach that law can have. And I can only say, looking back over the career I've had and the observations of what's happened, that every win in environmental law is a precedent for a better decision to follow it. So keep up that fire in the belly.
Thanks very much, Simon. I'm tempted to respond, but I'll leave it for the discussion and introduce Larissa Waters. Larissa is a practising solicitor, and she's one of the very few people I know who has formal qualifications in both the law and environmental science, which makes her a formidable advocate. She's been nearly 10 years with the Queensland Environmental Defenders Office. She's on the Management Committee of the Queensland Environmental Law Association, the Queensland contributing editor to the National Environmental Law Review, but most importantly, as of August the 21st, she is the Green Senator-elect for Queensland and will assume that office in July, when she'll be able to put her legal expertise into practice. Please welcome Larissa Waters.